In this video, I'm going to answer the question, what is a pretrial diversion program in a Georgia criminal, traffic, or juvenile case? I'm Paul Ghanouni, founder and managing attorney at the teen and young adult defense firm, where we focus on protecting the futures of people who are in their teens to their mid-20s when they get in trouble with the law with either a traffic, criminal, juvenile, or DUI case. Now, we often get asked, what is a pretrial diversion program? And a pretrial diversion program is a program that's authorized by law that allows the prosecutor's office in a case and the defendant or the defendant's attorney to come to an agreement that if the person who's charged with the crime ends up doing certain things, that at the end of that case, or at the end of doing those things, the prosecutor's office will do some things on their end as well. What these typically look like are, that the person accused of the crime ends up, without having to admit guilt in many circumstances, ends up having to do things like community service work. They may have to complete some classes. They may have to do certain types of counseling. They may have to pay certain court fees. They may have to get drug tested. They may have to be supervised by a court supervision officer or probation officer, something like that. And then at the end of completing all of the things that they've agreed to, the prosecutor's office will usually either dismiss the charges, dismiss some of the charges, or reduce some of the charges, again, depending on the terms of that agreement. Now, these programs are different from court to court and from county to county. You may see that in one county they do certain things, in another county they may do other things. The criteria for being able to get into these programs can be different from county to county as well. They can be different from charge to charge, and some counties have more informal programs, while other counties have very strict and stringent requirements for their programs. The other things to be aware of are that just because somebody doesn't appear to potentially qualify for a program at first glance doesn't mean that that still can't be negotiated with a prosecutor if there is a situation that makes it appropriate to do some sort of a pretrial diversion program in a particular case. The types of cases that we typically see pretrial diversion programs in are usually like underage possession of alcohols, shoplifting offenses, marijuana possession, some felony drug offenses as well. Now, these charges and these programs are usually only available for somebody who's never been in trouble with the law before, or who it's their first time going through a pretrial diversion. With that said, again, those things can potentially be negotiated on a case-by-case or a county-by-county basis, so don't ever assume that you can or you can't get into a particular program. Having a law firm helping you while you have a case that could be eligible for pretrial diversion can help you in trying to get into that program, can help you in trying to make sure that the terms of that program are the best terms that they can be for you and that you're set up for success in that, can help you in trying to make sure you understand what all you need to do to successfully complete that program, and make sure that basically everything that can be done is done for you. If you're dealing with a criminal, traffic, or juvenile case in Georgia and you're wondering if your case may be eligible for a pretrial diversion program, or if you want to try to get help getting into a pretrial diversion program, or to help be successful through the course of that pretrial diversion program, please contact our office for a complimentary defense strategy meeting. A member of our team will be happy to meet with you and go over the situation that you're dealing with and see if it's something that we can help you with. Thank you.